Bismillahirrahmanirrahim. So, my dear brothers and sisters, Assalamu alaikum warahmatullahi wabarakatuh. So, this is part 5 of my video lecture on the topic of state territory. And I was discussing about conquest, the taking of territory by means of military force. So, the current modern international law prohibited the use of force, Article 2, Clause 4 of the UN Charter. So no military occupation or acquisition of territory can be made by means of military force, and which is illegal, and no state in the world must recognize this as legal. So this is prohibited. So that's why conquest is no longer valid under the present international law. Okay, present international law. And we have one incident to illustrate Israeli occupation of Palestinian territories in the Six-Day War in June 1967. So why we call it Six-Day War? So the war ended in 6 days only, and all the Arab armed forces, many Arab countries' armed forces were defeated by Israeli army in 6 days only. And Israeli occupied Sinai Peninsula, owned by Egypt, Gaza Strip, West Bank, Jordanian, and then East Jerusalem, Jordanian, and also Golan Heights, Syria. So after this 6-day war and Israeli occupation, Security Council adopted Resolution 242, and then they reaffirmed the position of the principle of inadmissibility of the acquisition of territory by means of war or military force, and demanded the withdrawal of Israeli forces from territories occupied in the conflict. So this resolution was adopted in 1967. At that time, even the United States of America was in favor of this resolution. That's why there was no veto at all. But the only thing we could do against Israeli was declaring that this is illegal and invalid, and Israel must withdraw from the occupied territories. Just condemnation of Israeli because of its illegal act, but we cannot take any enforcement action against Israel. So because of for fear of veto applied by US. Okay, the next mode of acquisition of territory is we call accretion. Accretion is by means of natural forces, by means of nature. A state may gain territory, or also at the same time it may lose territory. One state may gain territory, another state may lose territory. This may happen slowly. If it happens slowly, we call it accretion. If it happens suddenly, we call it avulsion. So accretion happens slowly by means of the gradual, for example, gradual movement of a river bed. A river is a boundary river between state A and state B. There's a boundary river. State A constructed dams, and by means of that, the flow of the river moved on the side of the state B towards the state B. So meaning that by means of this, this is a gradual movement, but not by construction the dam. So naturally, after a long time, this boundary river has been moved because of naturally, and it has been come inside the territory of state B. So in that case, state B lost territory and state A naturally gains territory. So because of the gradual movement of a river or riverbed, or because of sedentary compilation. So this is called accretion. Accretion is gradual movement of by nature. Okay? It can happen slowly. But if happens suddenly, it is called avulsion. For example, the creation of an island in the territorial sea by means of volcanic explosion, or maybe even by means of the earthquake, for example, or sometimes because of tsunami. So an island can be born, a new island can be born, or an existing island may disappear. So this is aversion. It happens suddenly, it is called aversion. It happens slowly, it is called accretion. And this is as a result of the natural forces. A state may gain territory and may also lose territory. This is just for your general knowledge. Now, the last one is cession. Cession. What is cession? Cession means transfer of territory. And this is done through treaty, by means of treaty, from one state to another. So cession means transfer of territory, like transfer of immovable property, transfer of land in domestic law. Okay? But in international law, we call it cession, transfer of territory. And it may be made by a treaty. There must be a treaty. We call it treaty of cession. And we have so many methods of transfer of property, right, in domestic law. And transfer of property in domestic law, like for example, sale. And then we can have in hire purchase, we have, something like that. And then we can give as a gift. So this is so many ways of barter system, so many means of transfer of property. So also in international law, transfer of territory can be made same as transfer of property. Same as transfer of property. It can be by sale, it can be by barter system, exchange of territory. So it can be as a gift, something like that. But anyway, since this is a transfer of territory, the law of the transfer of property applies here. And also the same maxim in law of property. What is the maxim? You remember the maxim? Nemo dat quod non habet. Sorry, there's a typing typo error, N-O-N, non habet. Nemo dat quod non habet. Nobody gives what he doesn't have. Nobody gives what he doesn't have means if a person is not the lawful owner of the property, he cannot transfer property to another person. He cannot transfer valid title to another party. Non-owner cannot transfer a valid title. So that's why to be able to transfer valid title, the person who transfers the title must be lawful owner. So this applies to international law as well. International also only the lawful sovereign state can transfer its territory to another state. Okay. In the Palmas Island case also, the tribunal decided that the ceding state, means the one who makes cession, we got CEDE, seat is the verb form, seat, CEDE, seat. The ceding state must be the legitimate owner of the title, otherwise cannot cede territory or transfer territory. Since this is based on a treaty, cession is to be made in accordance with a treaty of cession. It has to follow the law of treaties. The normal formation and validity of treaty applies. So that's why there must be no duress, there must be no fraud, no coercion in the procurement of the treaty. So we can refer to Article 52 of the VCLT. VCLT means Vienna Convention on Law of Treaties. This is in Peel 2. You can study this Vienna Convention Law of Treaties. Article 52 of the VCLT. A treaty is void if its conclusion has been procured by the threat or use of force in violation of the principles of international law embodied in the Charter of the UN. So, a treaty is void. Void here means without any legal effect, null and void, totally void, if its conclusion has been procured by threat or use of force. Okay? The threat or use of force must be in violation of international law embodied in the UN Charter. Then, can you remember what is the article of the UN Charter which prohibits threat or use of force? Do you remember the article? Article 2, Clause 4 of the UN Charter. That's why this Article 52 is referring to Article 2, Clause 4 of the UN Charter. Threat or use of force is prohibited, which is a rule of jus cogens. That's why a treaty of cession is based under the pressure of the threat or use of force. That treaty is null and void. So that's one case on this point. Fisheries jurisdiction in bracket jurisdiction case. In bracket jurisdiction means this is jurisdiction state. If it is a merit state, it is put in bracket merits. No? So this is fishery jurisdiction jurisdiction stage of this case, not merits of the case. So in this case, ICJ reaffirmed the validity of a treaty procured by coercion. If a treaty is procured by coercion, the treaty is void, invalid. But on the facts of this case, so this case is based on this the dispute between the Iceland and UK, right? UK. Okay, UK. The Iceland expanded its fishery zones. Because of this expansion, the sea areas where the British fishermen used to fish, they become the Icelandic fishery zones. They cannot fish anymore. So that's why the British fishermen were angry, and the Britain government also supported their fishermen. They sent British Navy to the area to protect the British fishermen. So there was even a war to break out. So but later on, the two countries, they peacefully negotiated, they discussed together, and finally they tried to settle this amicably, peacefully, and they enter into 1961 exchange of notes. They enter into exchange of notes mean treaties, bilateral treaties, bilateral treaties. But subsequently, Iceland argued that these exchange of notes were not valid, because at the time of entering into this exchange of notes, UK was using force against Iceland. So that's why it was not valid. It was procured by coercion. But the ICJ rejected this argument. Why? Because on the facts of this case, ICJ decided that the history of the negotiations which led up to the 1961 exchange of notes reveals that these instruments were freely negotiated. They are free negotiation on the basis of perfect equality and freedom of decision on both sides, meaning that there was no hints of any coercion. There was no evidence of any coercion. So they were freely negotiated on the basis of equality and freedom of decision on both sides. No hints, no evidence at all of coercion. Because of that lack of evidence of coercion, ICJ decided that these exchange of notes were valid. They were not void on account of coercion. So this is the case which is an illustration for the coercion in the Treaty of Cession. Okay, now we move on to the next point in this topic. Under this topic, this is the practical side. Now we have studied all the theoretical side of the law, the principles of the law, but in practice, how territorial disputes are determined in practice. Now we are going towards the practical side of the topic. So when there are territorial disputes between states, these disputes are very serious and very sensitive. Even it may lead to war between states. So there are pressure of national sentiment, and then even for small islands, small remote islands, this island may have territorial sea 200 nautical miles, EEZ 200 nautical miles, and then exclusive economic zone, and not only EEZ, a continental shelf, and there are natural resources, richness of natural resources, even for a small and remote island. Because of that, territorial disputes are very sensitive, and we have to be very careful about resolving territorial disputes. Now, what is the position of the courts and tribunals, especially International Court of Justice, in determining territorial disputes? How ICJ decides? What is the jurisprudence of the ICJ in territorial disputes? So we did a research on this cases decided by ICJ, and we found that there are three-tier hierarchical decision rule. Three-tier hierarchical decision, meaning that 3 steps decision rule. 3 steps decision rule. First, ICJ will refer to treaty law. Second, will refer to the concept of iuti possidetis juris. We'll discuss later on. And finally, ICJ will refer to the peaceful and continuous exercise of sovereign activities. In French term, it is called effectivity. Sovereign activity is, in French term, it is known as effectivity. International ICJ decision, ICJ always use the term effectivities instead of sovereign activities. So these are the 3 hierarchical rules. I will discuss later on in the next part.